Hello friends, welcome to Law and GK. So friends, on this channel we discuss the contents of law and previous year papers of judicial services and other legal exams. So friends, in today's video we are going to discuss the preliminary exam paper of Bihar Judicial Services 2016. So friends, if you are new on this channel, I would like to recommend कि आप जो है इस channel को जल्दी से subscribe कर लीजिए because it will be very beneficial for you in preparation for judiciary and other legal exams. And while subscribing, don't forget to press the bell icon so that you can get the notification of our upcoming videos. And if you like this video, just click the like button over there and appreciate this with your friends so that they can come to know about this channel as well. And अगर आपको हमारे efforts अच्छे लगे हों तो in addition to like and subscribe, kindly give us a super thanks. Super thanks means कि आप जो है कंटेंट क्रिएटर की थोड़ी हेल्प कर रहे हैं उसको टिप्स देकर. आपको अगर वीडियो अच्छी लग रही हैं तो यू कैन हेल्प देम बाय गिविंग टिप्स. मिनिमम से मिनिमम जो है आप 20 रुपये भी जो है डोनेट कर सकते हैं. जस्ट क्लिक ऑन दी सुपर थैंक्स. सो लेट्स मूव टू क्वेश्चन पेपर. लेट्स सी व्हाट इज क्वेश्चन नंबर 1. ये क्वेश्चन नंबर 1 क्या कहता है? रूल अगेंस्ट परपेचुइटी गिवन अंडर द टीपीए डज नॉट अफेक्ट एनी रूल ऑफ. देखिए, हिंदू लॉ क्रिश्चियन लॉ पर अप्लाई होता है, मोहम्मदन लॉ पर ये नहीं होता. ओके, तो बी इसका आंसर रहेगा. Where is rule against perpetuity? That is section 14 of TPA. That is 2. Standing timber under TPA are immovable property not so long as swayed या फिर movable. Not immovable property. It is a movable property. C is the answer. Where it is mentioned section 3 of interpretations of TPA. Next 3. Instrument under TPA means testamentary as well as non-testamentary या फिर non-testamentary. It is a non-testamentary. C is the answer. Again interpretation से क्वेश्चन है ये सेक्शन 3 से. Next is 4. For valid attestation of an instrument under TPA, it is necessary that each attesting witness must see the executant sign the instrument or affix his mark. या फिर the executant must see attesting witnesses या फिर each attestant must sign the instrument in the presence of executant. C is the answer. Again interpretations section 3. Next is 5. A has a wife B and a son C. In consideration of rupees 5 lakh paid to him by his mother, B executes a deed by registered instrument raising his share of inheritance to A's property. A dies and C claims his share in A's property. C is bound by his instrument या फिर C is not bound. C is not bound. अब आप पूछेंगे कैसे? वो तो बाउंड होना चाहिए. देखिए, उसने किसको दिया है? ये B को, और डेथ का वो ये फादर की बाद में. अगर वो फादर को देता दैट कुड बी डिफरेंट, ठीक है ना, तब वो बाउंड हो जाता. उसने अपने फादर को नहीं दिया. प्रॉपर्टी किसकी है? फादर की. तो मदर उसे रिलीज नहीं करवा सकती. अगर अब यही इंस्ट्रूमेंट अगर इसकी ए की डेथ के बाद हुआ होता तब भी सी बाउंड होता. तो दो केसेस में बाउंड हो सकता है, अगर वो ए को दे या फिर आफ्टर ही डेथ वो मदर को दे. बट ये बिफोर डेथ जो है उसने मदर को दिया है, तो नॉट वैलिड. अब आप सोचेंगे कि 5 लाख दिए उसका क्या होगा? तो 5 लाख वो मदर रिकवर कर सकती है रिकवरी सूट लगा के. Next is C. A agreed to sell B certain quantity of gunny bags deliverable on a future date. Before due date, B assign his beneficial interest in the contract to C. A commits breach of contract. So C is entitled to sue A for damages not delivering the gunny bags. A is the answer. C is entitled because उसने assign कर दिया ना अपना right यहाँ C को. So C will come into the shoes of B. A is the answer. Next is 7. Provision based on doctrine of acceleration under the TPA is provided in section 27. C is the answer. Next is 8. A owns two adjoining property X and Y. A sells the property X to B, imposes a condition that for more beneficial enjoyment of the property Y, B shall keep open portion of property X and will not build upon it. Which of the following is correct? The condition is not valid या फिर condition is valid. कंडीशन जो है वैलिड है बिल्कुल. बी इसका आंसर रहेगा. कंडीशनल ट्रांसफर की बात कहाँ की गई है? सेक्शन 25 टीपीए. नेक्स्ट 9. ए मेक्स अ गिफ्ट ऑफ लैंड टू बी. सी sues ए फॉर पोजेशन ऑफ द लैंड while the suit is pending. बी ट्रांसफर द लैंड टू डी. मीन्स पेंडेंटलिटी जो ट्रांसफर हुई है. A dies and C obtains a decree for possession against B as legal representative of A. Is D titles affected by the rule of lispendence so as to be subject to C's decree? No, because B was not a party to the suit at the time of transfer made by B to D. If B was implicated as a defendant as a party in the suit, then he could be bound. Now अब देखिए C ने A के खिलाफ किया है और B को पार्टी नहीं बनाया, B ने जो है ट्रांसफर कर दी D को, तो B को क्या पता कि सूट चल रहा है नहीं चल रहा, ही इज नॉट अ पार्टी टू द सूट, तो उस पर वो इफेक्टिव नहीं होगा. B इज द आंसर. भाई doctrine of independence provided in section 52 TPA. Exercise 10, handing over the possession of mortgage property is required in English mortgage. B is the answer. Section कौन सा है? 58 and is provided in clause E. English mortgage. Mortgage by deposit of title deed. F है clause F. Conditional sale कितने में? C for conditional sale, E for English mortgage. Next is 11. Which of the following pair is correctly matched? Marshalling by subsequent purchaser. That is in 56. ये तो marshalling securities है 81 में तो. Right of mortgager to redeem. That is in 60 not 60A. Usufructuary mortgager ये 62 में ही है. इसका आंसर क्या रहेगा फिर? Correctly matched C is the answer. Next 12. Relief from equity court could be obtained. कैसे? How? Before adjudication of common law court या फिर after decision of common law court. Before or after? C is the answer. Next 13. Equity court could be approached as a matter of right, as a matter of grace. As a matter of grace. B is the answer. Next 14. An equitable interest is an interest recognized by Court of Chancery. A is the answer. Next is 15. A transfers. Next is 15. A transfer rupees 10,000 in 4% to B in trust to pay the interest annually accruing due to C for her life. A dies, then C dies. So the following is correct. B holds the fund for the benefit of C's LRs. Or B holds for A's LRs. For A's LRs, B is the answer because the benefit was only to C for her life only. ठीक है ना? Not for the benefiting the C's legal heirs. Now it would go to A's legal heirs. Next is 16. Where trust property consists of money and cannot apply immediately or at an early date to the purposes of the trust, the trustee is bound to invest the money on specified securities and on no other. Which section of Indian Trust Act contains this provision? It is section 20. C is the answer. Next 17. Which of the following section of Indian Trust Act deals with liability for breach of trust? 23. D is the answer. Next 18. The word and expression used in the Specific Relief Act but not defined in the Act have the meaning defined in Indian Contract Act. B is the answer. Next 19. Which of the following section of Specific Relief Act deals with recovery of specific movable property? That is section 7. B is the answer. 5 में क्या है? Recovery of immovable property. 8 में क्या है? Liability of person in possession not an owner. ठीक है. 9 क्या है? Defense respecting suits, relief based on contract. Next is 20. Which of the following pair is not correctly matched? Contract not specifically enforceable. This is in section 14 not 15. Power to award 21. Yes. Liquidation 23 है. Temporary perpetual 37. Not correctly matched. A is the answer. This is 21. Every promise and set of promise forming the consideration for each other is called an agreement. B is the answer. Where it is mentioned section 2E of Contract Act. Next 22. Communication of acceptance is complete against the acceptor when it comes to knowledge of proposer. D is the answer. Section कौन सा section है ये? 4 Contract Act. Next 23. A tender is an invitation to offer. B is the answer. Next 24. An agreement in the state of marriage is void. C is the answer. Section कौन सा है? Section 26. देखिए मैंने बहुत बार डिस्कस किया है, इसको आप ऐसे बना लीजिए. CMTLU लव. CMT लव. Agreement without consideration void. 25. Marriage 26. Assessment of trade 27. Legal proceedings 28. Uncertain 29. Wagering 30. These all agreements are void agreements. void agreement कहाँ से कहाँ तक है? 24 से 30 तक. तो अगर मान लीजिए सेक्शन पूछा है कहीं पे तो आप इसको इजीली आंसर कर सकते हैं. Next 25. In order to convert a proposal into a promise, the acceptance of the proposal must be absolute and unqualified. Yes, it is correct. A is the answer. कहाँ mention किया गया? Section 7 of Contract Act में. Next 26. A proposal can be revoked by the proposer by the communication of notice by the proposer to the other party if a lapse of time, failure of to fulfill a condition precedent. All of the above रहेगा इसमें. D is the answer. Section कौन सा है? Section है 6 Contract Act. Next 27. Which of the following is correct? अब बताना है यहाँ correct. All agreements are contract once they have been made between the parties for a consideration. ये सिंगल कंसिडरेशन की बात है यहाँ पर. देखिए फिर वही सेम चीज़ है, फिर फ्री कंसेंट है, फिर वंस दे मेड बिटवीन द कॉम्पिटेंट पार्टीज, मतलब कॉम्पिटेंट पार्टी है, फ्री कंसेंट है और कंसिडरेशन है. देखिए यहाँ क्या लिखा? फ्री कंसेंट ऑफ द पार्टीज कॉम्पिटेंट टू कॉन्ट्रैक्ट फॉर लॉफुल कंसिडरेशन, लॉफुल ऑब्जेक्ट एंड नॉट एक्सप्रेसली बार्ड बाय लॉ. तो डी इज द आंसर. सेक्शन कौन सा है? सेक्शन है ये 10 कॉन्ट्रैक्ट एक्ट. Next 28. A valid contract at the initial stage ceases to be enforceable subsequently due to intervention of unforeseen factors. The contract will be void since the time it ceases to be enforceable. D is the answer. Void contracts are mentioned in 2J of Contract Act. Okay. Next 29. In Indian law, a wagering contract is treated as void. B is the answer. Section 30 अभी discuss किया था. Next 30. A person who finds goods belonging to another and takes them into his custody is subject to responsibility in the same way as of a bailee thereof. C is the answer. Where it is mentioned section 71. Finder of goods position as a bailee. Next 31. An agency in the contract is terminated by principal revoking death of either principal agent, principal being adjudicated as insolvent. All of the above. D is the answer. And where it is mentioned in section 201 Contract Act. Next 32. The liability of surety under the contract of guarantee is coextant with that of principal debtor. C is the answer. And where it is mentioned? Section 128 Contract Act. C इसका आंसर रहेगा. Next 33. A agreed to sell a horse worth 5,000 for 1,000 to B. A's consent to the agreement was freely given. The agreement is a contract. Valid है ये. A is the answer. Next 34. Which one is the famous case related with general offer? That is Carlyle versus Carbolic Smoke Ball Company. C is the answer. लालमन शुक्ला किस पर है? Communication of offer पर. मोहरी बीबी minority. Agreement of minor is void. Macpherson versus Apanna. Invitation to offer. Next 35. Consent will be said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation and mistake. The term free consent has been defined in which section? The section है 14. 13 में है consent, फिर 14 में है free consent. Okay. 15 coercion, 16 undue influence, 17 fraud. All right. Next 36. Which statement is correct for an act of tort? It is a civil wrong. All civil wrongs are not torts. It gives a right and rem. All of the above. D is the answer. Next 37. A tort is a breach of duty which is imposed by law. B is the answer. Next 38. Who said that liability in tort law arises only when the wrong is covered by one or the other nominated torts? Said by Salmond. D is the answer. And this is pigeonhole theory of Salmond. Next 39. Qui facit per alium facit per se. Maximum tort is related with which act of the tort? That is vicarious liability. C is the answer. Next is 40. In a suit for damages on the ground of malicious prosecution, what is required to be proved by the plaintiff? He has been prosecuted by the defendant. This is the first and foremost thing. Prosecution was instituted without reasonable probable cause. Yes. Proceeding for malicious prosecution terminated in favor of the plaintiff. Yes. All of the above. D is the answer. Next 41. Maximum OB just EB remedium. Where there is right, there is remedy. तो right पहले remedy बाद में है. B is the answer. एक होता है EB just OB. उसका मतलब क्या है? ये वाला EB just OB. Remedy पहले right बाद में. B इसका आंसर रहेगा. Next 42. Which one of the following famous cases is related to an exception to the application of doctrine of voluntary non-fit injuria based on rescue cases. That is Haynes versus Harvard. A is the answer. Next 43. In which case the principle of absolute liability was laid down? That was MC Mehta versus Union of India. इंडिया में हुआ था ये एब्सोल्यूट लाइबिलिटी वाला. लेकिन फ्लेचर किस पे है? स्ट्रिक्ट लाइबिलिटी पर. इसमें मतलब क्या है? इसमें एक्सेप्शंस है, बट एब्सोल्यूट लाइबिलिटी में देयर इज नो एक्सेप्शंस. प्लेंटिफ इज लाइबल. नेक्स्ट 44. रेस इप्सा लोकिटोर इज अ रूल ऑफ एविडेंस. डी इज द आंसर. एविडेंस में कहाँ पर है ये? सेक्शन 106 में. एंड अप्लाई टोर्ट में भी होता है कहाँ पर? फॉर नेग्लिजेंस. थिंग स्पीक्स फॉर इटसेल्फ. 45. The standard of care required on part of defendant in the tort of negligence is of a reasonable and prudent man. C is the answer. Next 46. The rule regarding the principle of negligence was laid down in the leading case of Donoghue versus Stevenson. B is the answer. कई लोग इसको Donoghue बोलते हैं, Donoghue भी बोल सकते हैं आप, no problem. But the correct pronunciation is Donoghue versus Stevenson. Actually 47. Where a person willfully and without any justification is dealing with the goods in such a manner that another person who is entitled to its immediate use and possession of the same is deprived of that, it is known as tort of conversion. A is the answer. Actually 48. For the application of the rule of strict liability, which is the following essentials is required: keeping or storing dangerous things by a person on his land. Yes. No natural use of the land. Yes. Escape of the dangerous thing out of the land of the person storing and keeping it. Yes. D is the answer. All of the above. Next 49. Which statement is correct? Public nuisance is civil wrong as well as a crime. Public nuisance is a crime. देखिए nuisance जो है ना, if let's say A is doing nuisance to B, that is private nuisance. ठीक है, but they are asking for public nuisance. It is a crime and this is punishable as per CRPC and also provided in IPC. CRPC में जब जहाँ पर executive magistrate can punish for public nuisance, IPC में provision है 268 में. तो C is the answer. Next 50. The leading case in which the test of directness for determining the remoteness of damages was finally established in Re Polmis and Pernes Whitty and Co. C is the answer. Next 51. In a contract for a sale of specific good, if at a time of the contract goods have without the knowledge of seller perished, then the contract is voidable at the option of buyer. If a contract is void for both the parties, void रहेगा because both party was unknown that the goods was perished. C is the answer. Next 52. In an agreement to sell goods on terms that the price is to be fixed by the valuation of third party, but such third party fails to make the valuation, then the buyer seller cannot make the valuation and contract become void. D is the answer. एग्रीमेंट की टर्म है कि थर्ड पार्टी करेगी, थर्ड पार्टी ने किया नहीं तो दोनों बायर करेगा, मैं कर देता हूँ सेलर करेगा, मैं करूँगा मेरे अकॉर्डिंग होगा, तो फिर उससे बेटर क्या है कि कॉन्ट्रैक्ट को वॉइड कर दें. Next 53. Sohan, a fraudulent person posing himself a respectable person, purchased a valuable ring from Mohan, a shopkeeper, by giving him a check. Check was dishonored, but before the fraud could be detected, Sohan pledged the ring with Rohan, who acted in good faith and without notice of Sohan's defect of title. What is correct position? Mohan can sue Sohan, the buyer, to recover the ring. Yes, he can sue. Rohan's title to the ring is good against Mohan and Sohan, hence will retain the ring. This is also correct, but this is B is most appropriate. A भी गलत नहीं है, obviously वो तो केस तो उसके खिलाफ करेगा ही करेगा, but this is most appropriate. B is the answer. Next 54. A toy dealer displayed in his shop window some plastic toy catapults. B, a child of 6 years, was attracted to the toys and one plastic toy catapult was bought from the shop after discussion with the shopkeeper. While the child was using it, a toy catapult broke off and entered the left eye of the child, which had to be removed. The case is filed against the seller for damages. There is contention that it was sale by description, hence the seller is liable for damages as the toy was not of merchantable quality. या फिर नॉर्मल सेल बायर बिवेयर होगा, या फिर सेल बाय सैंपल दिखाया ही नहीं था, या फिर डी आफ्टर सेल ऑफ प्रॉपर्टी इन गुड वाज ट्रांसफर टू द बायर, हैज द सेलर नो. भाई वो मर्चेंटेबल क्वालिटी का तो होना चाहिए, थोड़ी है मैं थोड़ा सा खेला और हाथ में आ गया, आईज इंजर कर दी तो बच्चे की आंख चली गई। ए इज द आंसर। नेक्स्ट 55, ए सोल्ड द गुड्स ऑन क्रेडिट टू बी एंड डिलीवर द गुड्स टू बी to buyer shipping agent who had put them on board a ship. However, the goods were returned to the seller for repacking. Then the goods were still with the seller. The buyer became insolvent. The seller, being unpaid, refused to return the goods. Now, see, this is a tricky question. First, they are saying that वो शिप पर भेज दिए गए थे, मतलब सेलर की पावर से वो चले गए थे और शिप पर पहुंचा दिए गए। फिर वो कह रहे हैं दोबारा से वो रीपैकिंग के लिए आए सेलर के पास, मतलब नाउ द सेलर हैज़ अ सेकेंडरी राइट। सो अगर वो शिप पर नहीं भेजे होते, उसके पास ही रहते, तो उसका वहाँ पर राइट टू लियन भी रहता। बट यहाँ पर उसका राइट टू, जैसे ही वो अपने गुड से पार्ट हुआ, मतलब उससे अलग हुआ, वहाँ पर उसका राइट टू लियन जो है ख़त्म हो गया। Now, though the buyer has become insolvent, the seller too has lost his right of lien on goods. The goods belong to the buyer. Buyer को पे करना पड़ेगा उसके लिए। C is the answer. अब आप सोच रहे होंगे कि भाई उसके पास वापस तो आ गया, बट वापस जो आया है वो उसके पास एज अ बेली आया है, मतलब द सेलर इज नाउ इज वर्किंग एज अ बेली, वो रीपैक करके उसको वापस देगा। Next 56, in negotiable instrument, the great element of negotiability is the acquisition of the property by parties' own conduct and not by another's. That is, if you take it bona fide and for value, nobody can deprive you of it. Which one of the following is the authority of this proposition? It was Rafael versus Bank of England. B is the answer. Next 57, the law requires that every party to a negotiable instrument must be capable of contracting according to the law of the contract. What happens when a minor becomes a party to the instrument as a drawer or maker or endorser? तो क्या होगा? Whole instrument is void या फिर voidable या फिर valid. Minor is not liable on the instrument but it remains binding on the all other parties. D is the answer. Next 58, where an instrument requires endorsement and it has been endorsed, then what is the rule creating liability on it among the following options? Every endorser incurs liability to all the party that are subsequent to him. A is the answer. Next is 59. Which of the following option is not correct? A bill of exchange may have to be represented for acceptance before it is prescribed for payment. Presentment for acceptance is necessary only where the bill is payable at a given time after expressly stipulates that it shall be presented for acceptance. Bill is made payable at a place other than the place of business. The drawer and drawee have common interest in presenting the bill for acceptance. So A, B, C are true and D is incorrect. D is the answer. Next 60. When the holder of a check receives information from the bank that check has been dishonored, he should make the demand within 30 days. That other person shall return the payment within 15 days. और उसके बाद you can just file a recovery case, criminal case. Next 61, a small company may be one whose turnover as per its last profit and loss account did not exceed 2 crores or 20 crores of such higher amount as we prescribed which cannot be more than 2 to 20. C is the answer and where it is provided in section 285 of Companies Act definitions में. Next 62, inactive company means a company which has not been carrying on any business on or has not filed financial statement and elements return during preceding last 2 years. B is the answer. And where it is mentioned, it is mentioned in section 455, explanation 1. Alright. Next 63, the Companies Act 2013 has provided that in listed companies, appointment of independent director is mandatory and the independent director will be appointed from the list provided by the Company Law Board. No. From the list of person given by Ministry of Law, Company Affairs. One data bank maintained for this purpose. So data bank से लेते हैं, C is the answer. And where this is provided in section 155 of Companies Act. Next 64, the Companies Act has done tremendous job by providing companies social responsibility as a mandatory activity. The company has to comply with mandatory CSR norms where the turnover of the company is 1000 crore or more. B is the answer. Next 65, the National Company Law Appellate Tribunal consists of judicial and technical member. The chairperson is one who has been judge of Supreme Court or the Chief Justice of a High Court. The maximum number of members in NCLT has been provided. 11 members. A is the answer. Next 66. A, B, and C enter into an agreement for a partnership at will. The partnership deed contains the following provisions. Which of the following provision of the deed is inconsistent with the partnership at will? That there will be option for surviving partner to purchase deceased partner share at a fixed valuation. That dispute between partners, if any, shall be referred to arbitration. Every partner will have the power to nominate his successor. That if any partner wants to retire from the partnership notice certain fixed period. देखिए यहाँ पर लिखा हुआ रिटायर, तो रिटायरमेंट थोड़ी हो गई वहाँ पर, और फिक्स पीरियड थोड़ी रहेगा बिफोर रिटायरमेंट. तो पार्टनरशिप एट विल है, ये इनकंसिस्टेंट हो गया. डी इज द आंसर. पार्टनरशिप एट विल इज मेंशन इन सेक्शन 7 of Partnership Act. Next 67. By employed authority, each partner binds all other partners by his act in all matters which are within the scope and object of partnership. The partnership of general commercial nature, which of the following is not within the implied authority of the partner. देखिए implied authority की बात कहाँ की गई? सेक्शन 19 में क्या लिखा ऑप्शंस में? that every partner may pledge or sell partnership property. Yes, that partner may admit any liability in a suit against the firm. No, they cannot admit. ये हो गया wrong. Every partner may borrow money. Yes. Partner may engage servant. Yes. B is the answer. Next is 68. If a person who is minor according to the law to which he subject to admitted to which he subject is admitted to the benefit of partnership, it is claimed that his share of the partnership is not liable. His share will be liable. He can sue the partner to show the account. No, he cannot sue. He can enjoy for some time the status of minority even after attaining majority. No, ये wrong है. He can sue the partner for payment of his share profit of the firm. Yes, ये can कर सकता है. He can claim. D is the answer. Section 30 provides the same. Next 69. Where a partner becomes insolvent, he ceases to be a partner in the firm on date which declared to be insolvent. या फिर on date is agreed by him, या फिर date insolvency partner advertise, या फिर date on which the order of adjudication is made. Order की date से रहेगा. D is the answer. Next is 70. ABC enter into an agreement for partnership in which C remains a sleeping partner. It is found that C is adulterous relationship with B's wife. What is the correct line of action? B insists that firm be dissolved on the ground advance his actions. A advised to terminate C. C read for his act and insists to compensate the firm's loss. A opposes dissolution of the firm as it is not a ground fit for dissolution and advises to continue business afresh. D is the answer. इसके लिए आप केस देख सकते हैं. देखिए, adultery is not a ground for dissolution of the firm. केस है Snow versus Milford. ऑलराइट. और ये वाला पॉइंट जो हमने लास्ट वीडियो में भी डिस्कस किया था बिहार जुडिशियल सर्विसेज की ही. नेक्स्ट 71. कम्युनिकेशन मेड विदाउट प्रेजुडाइस इज प्रोटेक्टेड अंडर सेक्शन 23 of Indian Evidence Act. B is the answer. Next 72. Necessity rule as to the admissibility of the evidence is contained in section 32. B is the answer. Next 73. Delhi High Court issue guideline for protection of witnesses in Neelam Katara case. A is the answer. Next 74. A prosecutes B for adultery with C, A's wife. B denies that C is A's wife, but the court convicted B for adultery. Afterwards, C is prosecuted for bigamy in marrying B during A's lifetime. C says that she was never A's wife. The judgment against B is irrelevant as against C. B is the answer. देखिए, बहुत ही कॉमन क्वेश्चन है, बहुत ही रिपीटेड क्वेश्चन है. सेक्शन 43 जहाँ पर जजमेंट्स मेंशन फ्रॉम 40 to 42 आर रेलेवेंट और इरेलेवेंट, तो वहाँ पर ये मेंशन किया गया है. दिस इज इलस्ट्रेशन B of that section. Next 75. Which of the following chapter of the Indian Evidence Act deals with witnesses? That is chapter 9. D is the answer. And it is from 118 to 134. Next 76. Which of the following provision of Indian Evidence Act was omitted by Amendment Act of 2002? That was, देखिए 155 में जो है अमेंडमेंट हुई थी, तो उसमें जो है क्लॉज 4 थी वो हटा दी गई थी। देखिए जो ये सबसेक्शंस नहीं है, क्लॉज थी वहाँ पर, तो सी इसका आंसर देगा। 5 तो था ही नहीं, तो सी इज द आंसर। Next 77. Which of the following section of CRPC defines the term judicial proceedings? 2I. Next 78. In which of the following cases Supreme Court has issued specific guidelines regarding arrest? That is DK Basu case, DK Basu versus State of West Bengal. Very famous case on arrest. Next 79. What is the maximum amount of maintenance which can be ordered by a magistrate monthly? No limit. अब कोई लिमिट नहीं है. D is the answer. Next 80. Under section 164A CRPC, the victim of rape shall be sent to registered medical practitioner for examination within 24 hours. So C is the answer from the time receiving the information. Next 81. Which of the following subsection were inserted by CRPC Amendment Act 2005 in section 176? That is 1A and section 5. तो D इसका आंसर रहेगा। Next 82. The period of limitation prescribed in the code CRPC is not applicable to the offences under इनकम टैक्स, कस्टम एक्ट और फैमा। तो ऑल ऑफ दी अबव। देखिए जिनमें रिकवरी होती है, रिकवरी कभी भी किसी टाइम भी कर सकते हैं। दीज ऑफेंसेस आर, दे डोंट हैव एनी लिमिटेशन पीरियड। जब भी पता लग गया कि आपने कोई टैक्स इवेजन किया है, फॉरेन एक्सचेंज मैनेजमेंट में कुछ ऐसा किया है, तो उस पर कोई लिमिटेशन नहीं है। डी इसका आंसर रहेगा। नेक्स्ट 83. CPC Amendment Act 1999 and 2002 were enacted on the recommendation of Malimat Committee. B is the answer. Next 84. Which of the following landmark judgments of the Supreme Court deals with applicability of res judicata in writ petition? It is Darya versus State of UP. Next is 85. A court can return the plaint when the court has got no territory, no pecuniary, no subject matter, any of the above. D is the answer. And where the provision order 7 rule 10. Next 86. CPC Amendment 2002 came into force on 1st July 2002. D is the answer. Next 87. The provision for setting aside the arbitral award is laid down under section 34 of Arbitration Act. Next 88. The parties to the arbitration agreement shall appoint arbitrator within 30 days. A is the section कौन सा है? Section 11. Next 89. The decree or orders made by small causes court are revisable by district. Next 90. Who is authorized to abolish small cause court? That is state government. B is the answer. Next 91. In which of the following cases it was contended that the preamble to our constitution should be guiding star in the interpretation, and hence any law made under Article 21 should be held as void if offended against the principle of natural justice? This was A.K. Gopalan. This is A.K. Gopalan versus State of Madras. A is the answer. Next 92. Which of the following cases held that secularism is the basic feature of the Indian Constitution even before the word secular was inserted in the preamble? That was Keshavananda Bharati versus State of Kerala. B is the answer. Next 93. In which of the following cases the consensus of majority of the judgment was that basic structure of the Constitution could not be destroyed or damaged amending the Constitution? That was Vaman Rao versus Union of India. A is the answer. Next 94. A person who or whose father was not born in territory but who has his domicile in territory of India has ordinarily residing within territory for not less than 5 years of the commencement of the Constitution is considered as Indian citizen. कहाँ मेंशन किया गया? आर्टिकल 5C में. D is the answer. Next 95. Clause of Article 13 of the Indian Constitution, which was inserted by 24th Amendment Act, states that a Constitution Amendment Act passed according to Article 368 of Indian Constitution is law within the meaning of Article 13. Accordingly, be void if it contravenes fundamental right. Amendment was declared void in which of the following? That was Minerva Mills versus Union of India. C is the answer. Next 96. Which of the following is an essential part of rule of law and independence of judiciary? That is judicial review. A is the answer. Next is 97. The test of reasonableness is not a wholly subjective test. Its contours are fairly indicated by the Constitution. So A is the answer. Next 98. Taxation is an independent power of state and there is no fundamental right to be immune from taxation. A is the answer. Next 99. Protection in respect of conviction from offences is the essence of the following article, that is Article 20. C is the answer. Next is 100. According to clause 1 of Article 25 of the Indian Constitution, the freedom of religion is subject to the interest of public morality, health, public order, morality, health. All of the above. D is the answer. Next 101. Which of the following article of Indian Constitution mentions the provision of the post of PM in India? That is Article 75. C is the answer. Next 102. A person shall be disqualified for being a member of either House of Parliament if he is so disqualified under the 10th schedule. D is the answer. Next 103. Judges of the Supreme Court can be removed from their office by impeachment. A is the answer. Next 104. Which of the following has been held to be question of fact and not of law? Whether a fact has been proved when the evidence for and against has been properly received, whether a statutory presumption has been rebutted, whether an endowment is private or public, there being no question of misconstruction of a document involved. All of the above. D is the answer. Next 105. Chief Minister shall be appointed by the governor. B is the answer. Next 106. Absolutism means the state or quality of being absolute, a sort of government in which public power is vested in some person or persons unchecked and uncontrolled by any law or institution. The unconditional power of sovereignty vested in a monarch, an autocrat, or an oligarchy. All of the above. D is the answer. Next 107. Mandamus is issued to check the performance या फिर impede, compel. C is the answer. Next 108. Which among the following has the power to extend function of State Public Service Commission? That is State Legislature. लेचर होना चाहिए, ये लेटर रख दिया. B is the answer. Next 109. While proclamation of emergency is operation, executive power of union shall extend to giving direction to any state as a manner in which executive power thereof is to be exercised. Yes, it is correct. The power of parliament to make law in respect of any matter shall include the power to make law on subject which is not enumerated in the union list. It is also correct. So both are true. C is the answer. Next 110. The governor must remain conscious of his constitutional obligation and not sacrifice either political responsibility on or the parliamentary convention on the altar of political expediency. In each of the following case, constitutional obligation of governor were mentioned. That was S.R. Chaudhary versus State of Punjab. A is the answer. Next 111. Administrative law is the law relating to the administration. It determines the organization, power, and duties of administrative authorities. Who said this? Ivor Jennings. A is the answer. Next 112. State the similarity between constitutional and administrative law. Both are private laws. Both law regulate the highest norms of state. Both deals with organization and function of the government at rest. Yeah, both are public laws. Both are public laws. D is the answer. Next 113. The privilege to withhold document information under the administrative law is enacted in which of the following section? It is in section 123. C is the answer. Next 114. According to Dicey, the meaning of the rule of law may be discussed under which of the following heads? That is equality after law, a fixed rule of law, under law. No, it is before law, equality before law. D is the answer. Next 115. Casey Davis, in his book Administrative Law, gave several meaning to the term rule of law. Choose the correct option. Fixed rule of law, exclusion of discretion, both. A and B. C is the answer. Next 116. Doctrine of separation of power can be explained by which of the following? Same person should not form the part more than one of the three organs of the government. Should not form the part of two of the three organ. One of the three organs है ना. Any organ, no. One of the three organ. A is the answer. Next 117. In modern state, the executive function is further classified as quasi-legislative, quasi-judicial, ministerial, and purely administrative function. The observation is based on which of the following cases? In Menka Gandhi versus Union of India, B is the answer. Next 118. Delegated legislation in India can be decided for post-constitutional period. This was held in the Delhi Laws Act case. B is the answer. Next 119. Choose the function which cannot be delegated under administrative law. Power to give retrospective effect. Okay. See, this is wrong. Retrospective effect power cannot be given to anybody. Prospective effect can be given. A is the answer. Cannot be delegated. So, appointed day, commencement, application, suspension. These power can be given. Next 120. What is the disadvantage in delegated legislation? In case of gross violation of rights of people, delegated legislation can be withdrawn or amended suitably without such delay. This is advantage. There are chances to misuse the power which are given by the Parent Act, and thereby the executive may enjoy more power than Parliament. B is the answer. This is disadvantage. Next 121. Conditional legislation under the administrative law is also known as subordinated legislation, contingent legislation. It is contingent. Conditional है तो contingent रहेगा. No discretion can be enjoyed as there can be no rule making power. B is the answer. Next 122. The principle of natural justice is one procedural rule of administrative action. Consider the above statement. Which of the following are justified? No man should be judged in his own cause. Yes, it is not justified. All men should be judged in their own cause. B cannot be correct. So A is the answer. Next is 123. The court in almost all the democratic countries enjoy the power to decide the validity of the delegated legislation under the administrative law and apply the test. The above is related to which of the following? Test of substantive ultra vires and test of procedural ultra vires, या फिर where the Parent Act itself is unconstitutional and delegated legislation is unconstitutional. It is related to substantive ultra vires, test of ultra vires. It is related to test of substantive and procedural ultra vires. A is the answer. Next 124. Rule against bias can be discussed under the following heads. Pecuniary, personal, by subject matter. The personal bias is decided by the Supreme Court in which case? In A.K. Kripak versus Union of India. C is the answer. Next 125. Habeas corpus literally means have the corpus being the body. Under this case, habeas corpus was not issued. That was बतुल चंद्र वर्सेस स्टेट ऑफ वेस्ट बंगाल. बी इज द आंसर. ए के गोपालन में वहाँ पर हैबियस कॉर्पस पहले अप्लाई की गई थी. नेक्स्ट 126. द एसेंशियल ऑफ ऑडी ऑल्टरम पार्टम इज इशुएंस ऑफ नोटिस विदाउट हियरिंग या फिर टेकिंग एडवर्स एक्शन अगेंस्ट हिम या फिर डिप्राइविंग द राइट्स. एसेंशियल ऑफ ऑडी ऑल्टरम पार्टम इज नोटिस. अदर पार्टी मस्ट हैव नोटिस एंड शैल बी हर्ड. डी इसका आंसर रहेगा. नेक्स्ट 127. व्हाट इज एसेंशियल कंडीशन ऑफ मैंडमस? The petitioner must have legal right which can be judicially enforceable. A is the answer. Public authority concerned must do its duty, should not make demand for performance. No. SC 128. According to the constitutional provision regarding contractual liability of the state, which of the following condition must be fulfilled in order to make a contract valid, in which the government is a party? The contract made to be executed on behalf of president or the government as the case may be. Yes. Executive entry in the contract and expressly made by without authority. No. A is the answer. Next 129. Tribunal deals with service matters only. It is presided over by a judge, magistrate. No. CPC rule apply. No. It is decided based on the rule of law. No. D is the answer. Rule of evidence is not applicable. Next 130. What is the qualification of ombudsman? Lokpal shall not hold any office of profit. Yes. Member of Parliament. No. Carry on business. No. A is the answer. Next 131. Hindu law is a personal law. B is the answer. Next 132. The ancient source of Hindu law is are Shruti, Smriti, Digest, commentaries. All of the above. D is the answer. Next 133. Section 5(1) of Hindu Marriage Act provides for monogamy. A is the answer. Next 134. Under which section of Hindu Marriage Act judicial separation has been provided? Under section 10B is the answer. 9 में क्या है? RCR. 11 में क्या है? Void marriages. And 13 में grounds for divorce. Next 135. Section 16 of Hindu Marriage Act deals with the legitimacy of the children of void and voidable marriages. C is the answer. Next 136. A Hindu marriage may be solemnized according to customary rites and ceremonies of either party, bride and groom. D is the answer. And where it is mentioned? It is mentioned in section 7 of Hindu Marriage Act. Next 137. Son in class 1 of the schedule of Hindu Succession Act does not include adopted son, illegitimate son, stepson. See, I would say this question is not correct. How? Because see, legitimate sons are related to their mothers as mentioned in section 3 in related kinship, and adopted son is equal to son, but stepson is not mentioned. So if they want to include adopted and illegitimate son, then illegitimate son is only for the mother and not for the father, and they are asking in general, means for succession of interstate की succession जो भी होगी, that would be either they should have mentioned in case of mother or father, but stepson is not included. B could be the answer, but I would say the question is not proper. 138. Which of the following section is correct under section 10 of Hindu Succession Act for surviving sons, surviving daughters and mother of the male intestate? Each shall take one share. Very simple. A is the answer. And is provided in Rule 1 of section 10. Next 139. Section 14 of Hindu Succession Act. Any property possessed by Hindu female, whether acquired by her before or after the commencement of this act, shall be held by her as full honor. A is the answer. Next is 140. According to the Hindu Adoption and Maintenance Act, minor means a person who has not completed his age of 18 years. C is the answer. And where this is mentioned in section 3 clause C, definitions. Next 141. A female Hindu who is major and is of sound mind is legally capable to take in adoption a son or daughter if she is a widow, divorced, unmarried, her husband has completely and finally renounced the world, ceased to be a Hindu. All of the above. D is the answer. Section 8 provides for the female capacity of female to take in adoption of Hindu Adoption and Maintenance Act. Next 142. A junior male member of Hindu undivided family may be its karta when he is able and intelligent. Intelligence is without consent of co-partner family. If he is able, clever, only with the consent of other co-partner of the family. C is the answer. Next 143. What are the main sources of Muslim law? Quran, Sunnat, Ijma, Qiyas. All of the above. D is the answer. These are primary sources of Muslim law. Next 144. By which man a Muslim lady may legally marry? A Muslim. B is the answer. Next 145. With whom a Shia Muslim man is entitled to perform temporary marriage, that is muta marriage. With any of the above. D is the answer. Next 146. Whether a Muslim may take talaq in state of intoxication or under pressure? Yes, under Sunni Muslim law it is recognized, otherwise in Shia law it is not. A is the answer. Next 147. By the third pronouncement of talaq, which kind of talaq becomes effective? Talaq-e-Hasan. A is the answer. Talaq-e-Hasan, only one pronouncement. A is the answer. 148. Acknowledgement of paternity once made cannot be revoked. A is the answer. Next 149. In whose custody the Muslim illegitimate children will be kept? Mother. B is the answer. Next 150. Which of the following gift is not valid? Gift in future. Yes, not valid. Conditional. No. Gift based on wagering contract on agreement. D. All of the above. So friends, यहाँ पर हमने बिहार जुडिशियल सर्विसेज 2016 का प्री का लॉ का एग्जाम पेपर पूरा डिस्कस कर लिया है. अगर आपको इसमें कोई कमी लगी हो, कोई सजेशन हो, कोई एडवाइस हो, तो आप कमेंट सेक्शन में जाकर भी लिख सकते हैं. वी ऑलवेज अप्रिशिएट योर कमेंट्स एंड फीडबैक. एंड फ्रेंड्स, इफ यू लाइक द एफर्ट्स, काइंडली गिव अ सुपर थैंक्स. सुपर थैंक्स मीन्स कि आप जो है कंटेंट क्रिएटर की थोड़ी हेल्प कर रहे हैं, उसको टिप्स देकर। आपको अगर वीडियो अच्छी लग रही है तो यू कैन हेल्प देम बाय गिविंग टिप्स। मिनिमम से मिनिमम जो है आप 20 रुपये भी जो है डोनेट कर सकते हैं। जस्ट क्लिक ऑन दी सुपर थैंक्स। एंड अगर आपको वीडियो अच्छी लगी इसको जरूर लाइक कीजिएगा एंड डोंट फॉरगेट टू सब्सक्राइब आवर चैनल एंड व्हाइल सब्सक्राइबिंग डोंट फॉरगेट टू प्रेस द बेल आइकन so that you can get the notification of our upcoming videos. So friends, thanks very much for watching this video. Thank you.